Good evening again, and I'm so happy to welcome you all tonight's event to celebrate the launch of the latest issue 3.1. For those of you who do not know what Interactive Entertainment Law Review is, it is a peer review journal that aims to be the hub for legal analysis of interactive entertainment, video games, virtual, augmented, mixed reality, social media, and all related and emergent forms of digital interactive entertainment. It is published twice a year, so this is the first issue in 2020. And we have the pleasure to welcome three of the authors that contributed to the latest issue here tonight. Each of them providing a perspective on the often uneasy relationship between creativity and copyright. They are looking at it from different angles and in different contexts. And it's great to have them here today to talk together and try to draw certain links and insights from the arguments and analysis that they put together. Without any particular order, let me introduce the speakers we have here today. We have Oliver Brown, who is an associate at the law firm Munger, Tolles & Olson, based in Los Angeles, California. He graduated with great distinction from Harvard Law School, where he specialized in speech and copyright law. He also has a background in the music tech space, where he worked, or his expertise is as a professional musician, songwriter, and voice actor. The next speaker tonight will be Anthony Caton, who is one of my colleagues. He is a PhD candidate at CCLS, Queen Mary University. His research interests lie mostly within copyright law, creative industries, and interactive entertainment law. He's particularly interested in using extra-legal interdisciplinary analysis when it comes to resolving legal problems and answering legal questions. And a third speaker tonight is Daniel Lintman, who graduated from Thompson Rivers University in British Columbia in Canada, and currently works at Singleton Reynolds LLP in Vancouver as an articling student. His inspiration for his work, and the article in particular, came from many conversations he had with John Festinger during his law studies, and through the lens of a skateboarder and videographer. He began to perceive urban architecture and other forms of creative works as unusual canvases that potentially qualify for copyright protection as artistic expression. Welcome, all of you. Thank you for agreeing to be here tonight, and I'm very much looking for our conversation. Just a few household issues. I'd like to ask everyone to mute themselves unless they are speaking. We will have questions and answers session at the end of the event. So if you have any questions throughout the conversation, please post them in the chat. If the question is specifically addressed to any of the speakers, indicate that, and we will aim to ask as many questions as possible towards the end. Thank you. So, upon reading, looking closely at the articles, it's quite interesting to see that all three of you work with reference to customs, social practices within the video games and within the industry itself. and to some extent acknowledge the existence of legal pluralism, where the formal laws, the formal legal regime exists in parallel with semi-formal or informal set of rules that are followed by the community of players, the community of developers, game publishers. So I'd like to start with focusing on that, looking at customs. And the first question is addressed to you, Daniel. You refer to customs in the context of being informative in terms of how to align this sort of discord between existing practices within the video game and copyright laws and license agreements, where perhaps certain creations or certain aspects of video games or certain creative endeavors are not currently protected by copyright. How do you see customs informing potential legal reform? How they can guide either legislators or courts in understanding how to close this gap?
Well, I think that any new approach or proposition in law raises questions of legitimacy before it attains widespread acceptance. But I would argue that we can borrow from other areas of law which already recognize community customs. For instance, customary international law comes from the widespread use of norms in the international community, coupled with a recognition that those norms have binding effect. And while I'm not familiar with administrative law in other jurisdictions, Canadian administrative law features the principle of judicial deference, whereby judges who are reviewing the decisions of boards or tribunals will defer to those bodies when they have particularized expertise. So the proposition that I make is that we should treat the communities that mold unusual canvases, such as video game communities, as their own sort of discrete boards, and defer to the expertise that they've developed by existing on the vanguard of a rapidly developing technology. Because quite frankly, I think that lawyers and judges are out of their element grappling with the issues that arise, and legislators for that matter too, the issues that arise in video game copyright. I look at it as the Wild West of intellectual property, sort of like a frontier land where the rules are constantly shifting alongside the evolution of technology. And I think the only ones who can speak to what's going on there are those who play at the vanguard. And underlying all of this is, I see a parallel that can be drawn between the constitutional law principle of subsidiarity, which proposes that those closest to an issue should be the decision makers on that issue. And I think there are a lot of legal principles that are relevant to align the community customs and practices with formal legal rules, various ways of consultation. I think that law is reactive in a lot of ways, and especially in terms of litigation. If we were to consult experts, and I think that's already happening, I discuss the Solid Oak Sketches case, which involved Kobe Bryant's tattoo, which was featured in a basketball video game, and they consulted experts within the tattoo community, and they relied on their expert evidence to a large extent to determine how the tattoo community treats situations like this.
Okay, thank you. What do you imagine the process or procedure would be in determining which player community will be the one that determines the rules to follow? Because obviously even the player community is not homogeneous, and there will be varying opinions, even varying practices. So which one shall be the one that will or should prevail, in your opinion?
Well, I think that it's okay to have the power dynamics shift between discrete communities or within or between customs within communities, video game communities, because I think that's the byproduct of any disruptive industry or subculture. And I think that already there are always message boards and forums that are associated with any game. So I think that as this area of law develops, and if we start acknowledging community practices and allowing those to inform the law, I think that the communities could themselves could work out a system whereby they could decide, whether it be by electing board members who are the ambassadors for the community. But I think that already happens if you really dive into some of the conversations that are being had around modding in video games, for example, how source code and how players view the license agreement, terms of license agreements, whether explicit or implicit. I think those conversations are already being had. So leaving it up to the communities to really decide who would be their representatives I think would be an effective way.
Thank you. I will take it from here and ask next question or address next question to Anthony, that is looking in particular for solution for aligning the discrepancy between social practices in video games, especially in the context of in-game creations and the existing copyright law system, that coupled with the effect of license agreements often has exactly the opposite effect, and not acknowledging the creativity, the authorship, ownership of in-game creations. You seem to suggest that the most feasible way to deal with this is an industry response by amending the existing license agreements. You make specific proposals of how this can be achieved. Now, how do you see this process becoming mainstream? You do use an example of Minecraft's license agreement, but I wonder, why hasn't this been adopted widely by other game developers, by other virtual worlds and virtual environments? What do you think?
If you're asking me to speak to the reason as to why open-ended or generally user-friendly and user-favorable, arguably end-user license agreements like that used by Mojang in Minecraft haven't really taken off in the context of other companies, that's not really a question that I can, with my current and existing knowledge, answer. Because every company is going to have varying reasons and motives behind the end user license agreements that they're trying to sculpt and create. I can only really tell you, at least from experiences of my own, when a company says, hey, I want to write a really user-friendly end user license agreement, at the end of the day, no matter what happens, retention of their existing rights tends to outweigh any benefits that they perceive that a otherwise user-friendly or a user-favorable end user license agreement would otherwise kind of present them. I think that, to me, is perhaps, if I were to speak on the reason why it hasn't really taken off widespread. Otherwise, if it were, or if something like this were to happen, I think it would honestly require more of a social consciousness change and shift to facilitate that sort of thing. I don't think companies, and again, this is maybe me going out on a limb here, but I don't really see companies choosing to redress the imbalance. I think that one of the points that I eventually make is it is lamentable that there exists this power dynamic imbalance, because it is only the party who currently holds pretty much all of the power who can honestly redress it. And it's when it's their prerogative and there is very little for them to stand to gain from the perspective of their retention of their rights, exploitation of their IPRs, and being able to just carte blanche shut down other creative endeavors by users that may or may not threaten them.
Mm-hmm.
For them, retention of rights is almost always going to be preferable, because why give up that power? For a company that is just, I think there's very little incentive to do so, short of, again, a shift in social consciousness that would otherwise necessitate such a change. Users may be gravitating more towards these things, and you could make that argument. I mean, there is a reason why Minecraft at present is the most popular and most wide-selling game in the world. We're seeing some companies choose to adopt this, and we are seeing a shift in how companies are approaching fan-made content and user license agreements. I mean, a few companies did things correctly with Halo and Red vs. Blue, but then you have Blizzard and Nintendo, who's kind of steadfastly won't change. And again, I don't know if there's going to be change that doesn't otherwise come from social pressure or the law, but I also don't think the law is going to really change, because one of the primary points I make is, irrespective of what the status is in terms of copyright, it's so much easier for them to circumvent it through contract. That's fundamentally one of the issues. And again, when you have contracts of adhesion, or any contract that is kind of a unilateral contract that massively weighs in favor of the company, short of either change coming from the industry that they band together and decide is, how they should do things moving forward, or short of, again, consumers making an active choice in the way that they behave to maybe change these. I don't really think there's going to be a change, if I'm being completely frank.
And how do you yourself perceive, for example, the move from the Cyberpunk 2077 creators to include a feature that will disable music copyright? So enabling users to stream without fear of potential copyright infringement. Do you think that this is potentially a sign of such change in social consciousness, that the company is reacting in a positive way to existing social and creative practices within the environment, and they're trying to build them in sort of to enable it both technologically but also legally?
I think it's a convenient solution to a deep-rooted problem that isn't really doing that much. I think it's more indicative, as you said, maybe of a change in the consciousness of companies as to how they approach these problems. But at the end of the day, the question boils down to, is it enough? And I probably think the answer is no. Again, I think short of actually addressing the fundamental problems that have given rise to all these issues, and streaming is one example of something that has completely wholeheartedly not been envisaged by the copyright regulation and regime, and as a result we exist in a somewhat of a gray area where many of these issues are and continue to be untested. And the same goes for in-game creations as an entire set of creative practices that have never been challenged at court, and I theorize at least some of which should reasonably give rise to copyright, notwithstanding many of the intricate issues. And again, from an economic standpoint and from a functional standpoint, if you're being practical, contract is kind of the sledgehammer solution that just ignores everything and breaks through. It gets the job done. It's not pretty. Is it ideal? Probably not. Is it feasible? Kind of. But I wouldn't call it the correct solution. Again, where the fundamental problem, for me at least, is something that's far more deep-rooted. But it is a workable solution, if nothing else.
Thanks. Kind of turning the spotlight to the perspective of the industry rather than the players. I have next question for Oliver, who discusses protectability of video games as such, but also of their constituent elements and how the case law in US is changing, how the tide is turning in favor of increased protection of video games, and how that can actually cause issues for the industry and the developers, because it may negatively impact creativity that will affect the entire sector. Oliver, do you think that in the case of game cloning, the courts are taking into consideration the customs and social norms and practices present in the industry and accurately reflecting on them in delivering their judgments, or they go against what would be considered a normal practice?
Yeah, that's interesting. I think the answer is probably not enough. Hearing Anthony and Daniel talk about the importance of social norms for gaming audiences, I think the same is true for game creators, to the extent that, especially in American law, there just wasn't really a recognition of video game protectability for the first 10, 15, 20 years of the video game industry, beyond what was considered a standard of virtual identity, unless there was outright duplication of a video game, including source code. Any sort of mimicry that sort of fell below that standard was not considered a violation of copyright law. And so I think social norms and social opprobrium kind of came to the forefront as the only means of video game creators protecting themselves from follow-on creators that may have had bad intentions. So what I think happened was, over the next 20 years, there was sort of a culture of copying that emerged, much like with remix culture in hip hop, or whether it was homage in architecture. Architecture, I think, is similarly in the United States a field that uses customs and social norms as the primary means of sort of distinguishing between good copying and bad copying. And in all of these fields, I think copying culture leads to a great deal of creativity, into a great deal of cultural conversation. And then the question becomes, as there's sort of a course correction and copyright law becomes a little bit stronger, which is certainly happening for video games in the United States, it looks like, with a string of district court opinions over the past 10 years. But the question becomes, is copyright intervention going to maintain and support the existing creative industry, or is it going to hurt it? And I don't think that the new sort of protective streak in the United States, at least, has given enough credence to how important copyright has become for video games. When you course correct, I think the great risk is that you start protecting things like genre. You start protecting things like style, which has been an increasing fear in music copyright as well, and film, instead of protecting the really labor-intensive and specific bits of expression that copyright is designed to protect. It's just very difficult to find the line. And so I think the problem and the difficulty has become that there's an important distinction, right, between what law and what custom can do. Law serves sort of a normative function, right? Law tells us what the world should be like, whereas social norms and customs tell us what the world is like already. And that's an important thing that I think we're losing when we take a really strong normative stance in law, is we sort of ignore what is existing practice in an industry. And in video games, it's been a lot of follow-on creation and homage, parody from game to game. And I don't think that judges are very well equipped to really understand cultural norms and industry practices, and juries less so, especially when the largest video game studios are the ones who are able to come into court and make really good arguments that what's happened here is theft. I think you end up with some pretty bamboozled judges and juries, creating some pretty shaky precedent.
I found there was quite a contradiction between the court's series of decisions, later decisions, where they're having very little sympathy for copying. And it's based on the argument that video games as a new type of medium now affords nearly limitless possibilities. So that's the kind of one of the arguments of the court, but at the same time, as you said, there is the sort of danger of protecting things like genres and sort of stock features or industry standards, for example, when it comes to user interfaces, something that is expected and desired by users and developers alike. How do you think this potential conflict can be addressed, where the courts are heading towards perhaps overprotection? Game developers are avoiding lawsuits in fear of setting precedents, and the social practice goes on and potentially exists in contradiction to what copyright license agreements and existing case law suggest. How do you see a possible solution to aligning these coexisting normative or semi-normative systems?
Yeah, I mean, so there is an obvious contradiction between the early case law and what we've seen in the past 10 years. And I think the question becomes, since like 1985 till now, what has happened? Why did judges sort of move from an ignorance and kind of an obvious contempt for the video game industry to the real care and caution that we see in judicial opinions about it today? And the answer is like several $1 billion is what changed. The video game industry became a multi-billion-dollar industry, and they got better lawyers, and they got a lot more visibility, and I think they got a lot more cultural credence in American culture and beyond as an important part of our creative culture. So I think now with this sort of intellectual 180 that we've seen in the courts about video games, how do we realign? I mean, there's two different problems. I think there's straightening out the case law with earlier precedent so that it makes sense. Spry Fox, which is a case that I talk about, and Da Vinci, two of the more recent district court cases, do some sort of legal jujitsu and judicial backflips trying to get that stuff to align with the earlier case law. So straightening that out is one thing, but then there's also just how do we create a functional system, which I think is ultimately what you're asking for dealing with copyright in video games. And I think the two most important things that we can do are, to whatever extent possible, taking this out of the hands of juries and back into the hands of at least judges. I think there's a lot more instability when this stuff actually makes it to a jury. And that's why really since 2012, we haven't seen an important video game copyright case in the United States make it to summary judgment, is because studios on both sides are just absolutely terrified of what a legally difficult and protracted battle full court case is going to be. And we just have no idea what the outcome is going to be. And when there's millions of dollars on the line, it's simply not worth it to take it past that stage. So I think if we can keep this in the hands of practiced courts and practiced judges, as opposed to letting things go to juries, that will go a long way. And I think the way to do that is to change the terminology around things like substantial similarity, which almost always are fact-specific determinations that need to go to juries, back to some of the older standards like virtual identity, which left this at least, it gave judges, I think, a lot more power to stop unjust cases at the motion to dismiss or summary judgment point. I think that will do a lot to at least get us a more precedent to, because I think there's an obvious chilling effect that's happening on creativity when follow-on creators don't know whether what they're doing is appropriate, whether it's going to cost them a huge amount down the line. And I think the final thing that I would say is going to be important moving forward is that there's an increased trend, hopefully in the United States, towards blanket licensing, at least in music. And I think it would be really interesting to see that explored in greater depth in the video game industry as well. The idea that following creation can be acceptable so long as there is a statutory price that's paid for what's taken, and to treat that, absent cases of bad faith, as something that can be applied retroactively. So at least we can have more clarity. We can have more cases that are actually making it to a judicial opinion. So that, I think, is my big three-part rant about where we could go in the United States. I'm not sure all of it makes sense, but it's a difficult issue. We'll see.
Thanks a lot. Staying with the topic of creativity, which obviously runs through all the three articles, and all three try to address how to determine a legitimate creative space. Where does creativity begin, where it ends, where we talk about inspiration, where it is mere imitation, where the end user's rights begin, and where the copyright owner's rights end. So kind of trying to identify those boundaries. I have a question for Daniel that talks about the magic circle in his article as being an area within the game that should be free of legal interference, that for as long as the user acts within the magic circle, within the game, that action, that behavior should not have real world impact. And I just wanted to talk a little bit about this concept. And do you think it is still relevant? Can players work with the concept of magic circle, or is that something that has proven to be a mere fiction?
Well, I think with the development of video games and how prolific they are, and as Oliver was saying, they're now a commercial juggernaut. There's no, I think that the traditional conception of the magic circle was based on a philosophical theory around the playground, the sense of the playground, and the rules of the playground are separate from the rules of real life, as it were. But now that augmented reality and virtual reality are increasingly becoming a part of our lives, video games interact with the real world in a very significant way. And the way that since there's so much commercial power behind a lot of the dynamics nowadays, I think courts are starting to recognize, or have been for quite some time, that the activities that take place in a video game have real life effect and real life value. Examples being the RuneScape case, where there were actual criminal assault charges laid against people who extorted an in-game item from somebody. There's also the Bragg and Linden research case where a person in Second Life exploited a glitch and attained a bunch of in-game property that was for a fraction of its actual value, and that real estate, that in-game real estate, becomes valuable in real life. People can sell the in-game assets now, and so I think that has has garnered a lot of attention from the law, and I think that I don't think we should draw the line between unusual canvases that are still eligible for protection and those that are not, unless we are asked to. Because if we take that approach, then creativity can thrive.
Thanks a lot. I think it's very difficult to think about any space, physical or virtual, at the moment, that would be free of any legal intervention. And more so video games, which are becoming more and more integrated in our lives, and our lives are being more and more integrated in video games, and perhaps even resembling video games. So I think that concept itself has to be redrawn or be seen as very dynamic in order to capture the nature of video games and the interactions of users with the game itself and each other. All of you, to some extent, discuss the role of users as creators, as someone who, through play and interaction, engages in an endeavor that the law potentially recognizes as protectable under copyright. Anthony, this is a question for you. What are the circumstances that justify treating users as creators? And how do you see that analysis going forward with games becoming potentially more immersive, more interactive, technologies such as augmented or virtual reality starting to arrive into our homes potentially? Will that change in any way?
At least in terms of the context of understanding players as potential creators, I think the cop-out answer is it depends, because I think there are so many fundamental questions that precede it, which need to be kind of resolved and determined prior to how you might want to go about understanding players as creators. One point that I do make in my article is invariably the type of play that takes place in any given video game invariably is going to differ, and accordingly is going to shape whether or not that type of play, irrespective of what that system might be, would be capable of being protected under any of the copyright regimes, whether it be American law, British copyright law, or European law. I think to some extent as well, it's shaped by this idea of whether or not you think form is ultimately a bigger contingent factor for identifying the types of works that we want to protect under copyright, whether substance, the qualities of the work, if you will, are the variables that dictate what ought to be protected, or authorship and the types of authorship. And accordingly, depending on which one of these metrics you choose, you're going to have a very different question. You're going to have very different answers about the types of creativity per se that should be protected. With respect to more what I talk about in my own article, I mostly focus on this idea of to what extent can players within the context of playing the game reasonably be considered authors. And I think the answer for me at least is, under a European perspective, it's the extent to which players through their gameplay can otherwise exercise free and creative choice in a way that's not overly dissimilar to the requirements have been set out by the ECJ, looking at FAPL and the idea that football, owing to its limited nature of choice, not so much the numerical nature, but the quality of choices being made, the idea that, especially rule-based or function-based decision-making is less likely, or at least faces more overt challenges to being considered free and unrestricted and therefore creative choices for the purposes of understanding what kind of works might otherwise be protected. I think those are fundamentally the issues. It really depends. Every game is going to be different. Every factual matrix is going to be different. But at present, there aren't really clear ways of talking about it. And it's this idea that, the way that we conceive of players as creators in the past, if you look at the idea that play was considered to be not overly different to changing the channels on a television versus play now, where you have games that encourage creativity as part of their core gameplay. It's at the heart of it, right? Mario Maker is a game where you build literal levels in other games for people to play. You have games like Spore and Dream, which have creation elements that are akin to creating games and levels for other people, but also give you fundamental tools that aren't overly dissimilar to a word processor or a creation program. And these tools are only getting more advanced as time goes on. And if you compound that with like extremely open-ended games like Minecraft, where you can literally build an entire computer within the context of Minecraft, or new virtual reality games that straddle the divide between creation tools that allow you to, through virtual reality or augmented reality, make paintings. The lines between play and creation are simply increasingly getting blurred. And yet there is no way, and there's been no established basis or precedent to distinguish between traditional acts of creation versus contemporary acts of creation, especially those which so readily incorporates pre-existing elements, not dissimilar. Because otherwise then you get this, it's not necessarily a unique problem for video games, because you can see this in music, you can see this with remixes, you can see this with collage art, but video games represent, for me at least, and similarly a lot of these interactive works represent this critical point where so much of this internal creation is going to be contingent on existing assets and existing rules and existing concepts that lend themselves well to this idea of functionality, and concepts which ordinarily would preclude them from receiving protection, even though, depending again on the metric you look at, they might otherwise be capable of protection, or at least being seen as desirable for protection. For me, that's the issue.
Do you think that copyright can cope with this new form of creativity and interactivity that this new type of media offers?
I don't think copyright was capable of protecting creativity prior to this. I think it's just worse now.
What about you, Daniel? What do you think? Do you share this view, or are you more optimistic on what copyright can achieve?
I think I currently share that view, but I'm a bit more optimistic with the potential of where it can go, because maybe partly because I'm still early in my legal career, but I think that there is still space to grow and to accommodate new forms of artwork, and I think that it's just the common law just needs an open mind and needs to step into the shoes of creators a little bit more often.
Thanks. Oliver, do you think that copyright can accommodate creativity, and looking at the perspective that you explored in your article within the industry rather than in terms of players themselves, but can copyright foster creativity in the industry, or will the current trend, as you described, have a negative impact?
I think it could. I think that we need a sea change in the way that we deal with derivative works in the United States and abroad, and I think we'll start to see that change. I think it's the primary barriers are economic more than they are legal. It's the power imbalance between big creators and big studios and little creators and little studios. What we're seeing is just amassed libraries of huge amounts of copyrighted content in a very small number of corporate entities, who can then leverage that library of content against small creators sort of when they wish to. And so, I mean, that's the instability of the copyright regime means that new creators must rely on the tolerance and the goodwill of the previous generation of creators that influence them. And predominantly all of those works are held by a very small number of corporate entities. And so I think that if we're going to make copyright equitable and make it support the progress of the arts and sciences, which is what it should do in the United States at least, then we're going to need a much lighter touch and a much easier means of borrowing and being inspired by previous works, that have less of a risk of serious financial and legal harm for those new and independent creators. We need ways for those new creators to access previous works, to mess with those works and create new things, and to do so without worrying that the ultimate outcome may be millions of dollars in legal liability.
Super, thank you very much. Before I'm going to hand a sort of ability to ask question to our audience, is there anything that either of you wanted to add if you had the last 30 seconds to comment? Was there anything specific that you wanted to highlight before we close and open the forum to questions? I've noticed that Anthony had asked a question himself, that if the law serves as a normative, if it serves a normative function, to what extent are the industry practices a very product of those norms? So how the laws themselves determine which practices are thriving and which are not. So if copyright is not fostering creativity as such, potentially, or hindering creativity, are those social practices taking place? Do they embody creativity, or is creativity therefore limited? How they can inform potential reform or change in direction of the existing statute, regulations, or case law? Do you have an answer for that, Anthony? Is that a rhetorical question?
It was more a question for Oliver, if I'm being completely honest. But I mean, if I have to answer it, I personally have the mindset that some of the issue with creativity at present is a product of norms, and it's not so much. And I risk venturing into territory that is far outside the context of what my article touches on, but I would say briefly that I think one of the fundamental challenges for the video game industry is the idea that the way creativity and the way creative products have been designed and construed by copyright law has, to some extent, privileged certain types and acts of creativity to the detriment of other types of creativity. One of the big examples of this that's evidenced in it is the fixation by cases on visual elements as a way of addressing what otherwise might be termed unconscionable or unreasonable taking by another company. I think Spry Fox is the obvious example where resorting to what tools that they had, the idea of using the visual comparisons, when, let's be honest, I think the visual comparisons weren't really a good example of what should be substantially similar or even copyrighted for the purposes of what otherwise is verbatim cloning. I think that's the problem for me. It's the idea that you've had to resort to tools for other types of copyrighted works themselves, which are imperfect, to resolve novel problems that are presented by interactive creations. And the law isn't equipped to handle those things. That's my perspective, which I think is what shaped a lot of the industry norms. It's why we see, at the end of the day, still a prevalence of game cloning. We see more companies choosing to make secure investments in making games within the same genre. You saw that with Fortnite, Apex, Battle Royale games everywhere. It's unquestionable that usually in the video game sphere, a game gets trending and every company makes games in that same genre, in that same vein, sometimes identical clones, but they change the art assets, they change the narrative, and then it's fine, because under copyright law, that would be fine. And if that's what you think copyright law should protect, that's great. If you think, like me, that maybe these elements aren't necessarily the be-all, end-all for the types of creativity that take place in the construction and the creation of a video game, and more so when you have a problem like game cloning, and you have to resort to these other elements to deal with things like game rules or play it's what leads to these kinds of strange cases like Spry Fox. That's one of the concerns I have, at least.
Daniel, Oliver, do you have anything that you'd like to add to that? Sort of contradiction between how the laws themselves determine the social practices and therefore shape what creativity is perceived to be.
Yeah, I mean, I can respond really quickly. I think one thing that's interesting, and this also responds to a point that Anthony made earlier about in sort of the power balance between creators and audiences, that creators are the ones, especially big studios, the ones holding the keys and have the powers to, are the only ones with the power to change these license agreements and, you know, create new standards. I think I'm a little bit more optimistic, and I don't think that necessarily is true. In the context of norms versus law, sometimes norms emerge completely in conflict with law. I think that for almost a century, right, music studios and major labels were the ones that were holding the keys in their relationship with music audiences, and Napster, for better or worse, completely changed all of that in 2001. And that was an example of just a critical mass of users taking part in illegal behavior that ultimately shifted the entire industry as a result of shifting the norms of what we thought was acceptable behavior, and law had to follow along after that. And I think we're still feeling those effects, and it's possible that that's what's happening with UGC and video game content too, and with cyberpunk, what you were seeing. Law and major industry having to just recognize what users are doing, and that there's always going to be a symbiosis between follow-on creators and audiences and the original creators and big studios. And so I think sometimes law and industry have to respond. And so users have a lot of power, and so do follow-on creators.
Thank you. Daniel, do you want to add something to that? And then I'm going to open the forum for questions.
I would agree with the idea that law is often informed by the customs, and in any disruptive subculture or art form, I think that there's always going to be fringes that develop in contrast with law or in spite of law, and I find those endlessly fascinating and rich forms of expression. My research for my articles began with other subcultural art forms such as tattoo art and street art, and then eventually arrived at video games. But I think we should interpret intellectual property law in a way that views disruptive customs as informative rather than prescriptive, and apply the law in a way that matches the fluidity of the existing customs within subcultures. And that really sort of respects those communities' desires to remain subcultural and underground, because that's often what gives them their essence and what makes them desirable to those communities. And video game customs evolve as quickly as the underlying technology, which means it'll always outpace the slow developments of the law, in my opinion. So if copyright has any hope of keeping pace and balancing interests effectively and fostering creativity, I think that it needs to be informed by the context of the communities that are practicing these various subcultures, whether it be video games, tattoos, street art, any unconventional art form.
Thank you so much, Anthony, Daniel, Oliver. Thank you for being here tonight and sharing your opinions and insights on creative spaces and what role copyright plays in defining them, whether in a positive or a negative way. I'm going to ask now the audience if they have any questions. You can either type them in, or feel free to unmute yourself and pose your question. If it's addressed to a specific speaker, please let us know. Thank you. Hello, John.
Hi. I have a comment, and it's going to be fairly high level because getting into the depths of this would take far too long, and entire courses are taught on these subjects by me and by others. But in terms of, I start with Daniel's paper in terms of creating community. You know, one of the questions is, how do you define the community that then defines what the norms are? And that's a struggle. And I want to point out that that is being done all the time, but in a very uncomfortable milieu for video games and for video game companies. It's being done in broadcast and telecommunications regulation all the time. So in Canada and elsewhere, the independent production community gets defined by the regulator, and certain rules are promulgated in their favor and deference is shown to them. So we do have a process, but it requires kind of supervening regulation that defines community of interest. In telecommunications, the users, the consumers, are more and more protected by the regulators and are defined more and more as a community. Going on to Oliver and Anthony, I do want to point out that at least in Canada, and I think I see evidence elsewhere as well, that there is enormous tension between those administrative structures that do define communities and are shown deference. Both the communities are and the administrative bodies that define them are, and copyright law. So copyright law still ends up being a universe apart from the community definition. So that kind of unified field theory has not come into existence yet. So I'm sorry if this is vague, time only permits something that's very high level, but if I may do an ad for an upcoming interactive entertainment law review issue that we've been talking about as editors, I think as we explore issues of antitrust and competition law and regulation that may be coming to the digital media industry, the internet and video games directly or indirectly as a result, some of these issues will become more clearly defined and understood. So hopefully that was helpful.
Thanks, John. We have one question from Mike. Mike, go ahead. Please keep it brief because we have 6 o'clock, which officially is the time where the event goes to an end.
Well, I think I can make the question at least relatively brief. I can't make any promises on the answers. Talking about norms and the use of community norms as a means to lead to regulation, or a need, as a means to move kind of the ball on the law, though, to what extent do you think there might be a risk of those norms effectively being shaped by the industry, by those who have power? I mean, just thinking in one example, we now have in trademark kind of this idea that if people think you need a license, you need a license, rather than that following from doctrine logically. So, I mean, to what extent are those kind of risks going to be in play?
Mike, I assume you're addressing that to me. Am I right?
You or the panel or anybody.
All right, well, I'll be very quick. I'm very worried about exactly what you're saying. I think it's a huge danger. I'll defer to the panel.
I mean, I kind of agree with Mike, and I would go further, and I'd say I'm not convinced that even community norms themselves or certain community leaders are necessarily always going to be the best equipped to do that sort of thing. You could look at how certain communities in certain niches have developed their own set of guidelines, or certain individuals have, based on their position within the community, have otherwise shaped the reception of many other things within the community. Again, Smash is one key example, but even in fan fiction, there are certain norms depending on which group of fan fiction you're talking to are going to have wildly different opinions on how, I guess, otherwise traditionally understood copyright types of, I guess, function and purpose are going to be construed for the purposes of their own community and what ought to be taken, what ought not to be. I mean, the very issue of canon for fan fiction remains a huge dividing criteria, and I'm not convinced that that is necessarily the best way to go about it, personally. Or at least I don't think it's the most straightforward, in the very least.
We can't hear you, Oliver. Yeah.
Sorry, I was going to say, just to jump in and preach to the choir a little bit with everybody else who's fear-mongering, I completely agree. Number one problem, big problem. And I think it's really, right now is a very pressing moment for that issue, especially if anybody's been following what's been going on with fan fiction in China over the past couple of weeks. That it's important to note that the creation of certain kinds of works actually is a means of realizing community intertextually, as John Fiske would put it. That when we make certain kinds of, whether it's fan fiction or derivative works, sometimes that is the entirety of the community practice. And when we let industry or even government determine those social norms, it becomes a political issue where oftentimes we're marginalizing the group itself in ways that can be really dangerous. And so I think it's something that we need to be on watch for.
Thank you. Unless we don't have any further questions and there are no other comments, I'm going to close the event for tonight. Thank you very much for joining. If there are any further questions in the chat, or you think about a question later, feel free to email us and we can continue the conversation elsewhere. Thanks a lot to the speakers for making the time and being here tonight. Thank you for publishing with the journal. And I'm hoping this is going to be a first event in a series of many, and we will see you and many other people again soon. Thank you very much. Have a lovely evening and take care. Bye, everyone.